Mr. Kelly Shackelford from First Liberty. How are you, sir?
Great, Glenn. Happy to be with you.
So let's take this apart. First of all, is it illegal to leak this document?
I am not aware of any criminal violation. Okay. Obviously, it's an attack upon the institution of the court, and I don't know if people understand. I mean, the court will never be the same. I don't know what they're going to have to do now, but the ability of all the justices have 4 clerks. These are some of the brightest young attorneys in the country. They bring in new ones, and the ability to share with your own clerks the opinions you're working on. I mean, I just think it's going to damage the court permanently, and that's the reason why this has never happened. And we've crossed that Rubicon now.
I'm not sure that
it will never be the same.
I'm not sure it will change forever if they put the hammer down on anybody that was involved. Wouldn't that send a strong enough message to bring it back?
I hope. I mean, number one, are they going to figure out who it is? I mean, I think it's highly likely to be one of the 12 clerks for the 3 liberal justices. I mean, what if, God forbid, it ended up being involved with a justice? I mean, to me, I think that's impeachable. But I just think that people don't understand this is like sort of shooting a rocket at the Supreme Court. It is something that we might not return from, as far as the court being able to be what it was, which is the ability for justices. I don't know if people know this, Glenn, but what happens is there's a majority and a dissent, and you begin writing. They vote just a few days after the argument. They vote, and they start to write on the opinion. The majority writes theirs, the dissent writes theirs, and they share those. And people end up being convinced. This is the marketplace of ideas in a different way, but it's very important. They want to know what the law is. What does the law really say? Oh my gosh, I didn't think of that. And people switch, and there's lots of that's happened where people go to a concurrence or a dissent to the majority. And if you can't share the opinions and have that discussion without people, taking what's being written and taking it out in public to try to use it as a political tool, I mean, you just destroyed the internal deliberations that go on and the exchange of ideas. It's a really horrible thing what this person did.
What about the idea that it might have been a conservative clerk that thought maybe they're going to switch to the other side? This will lock them into position.
It doesn't make sense on a lot of levels. I understand people think it's really, really cute because it locks them in. But I mean, number one, the whole point is that conservatives don't do that. Conservative justices are actually restrain themselves from politics, and they say, no matter what I believe, I'm going to follow what is the original meaning? What is it? The whole philosophy of those people is not to warp the court into what they want it to be. That's clearly a liberal approach,
right? And that is clear in this ruling. I mean, that is mentioned several times that we are not a political body. We can't acquiesce to. We have no idea what this is going to do with the American people, but we can't care about that. We have to do what our job is, and that is to interpret the law against the Constitution.
And here's the thing about that, Glenn, that nobody talks about is this is talk about populism. This is a massive return of power to the people and away from a few oligarchs who control everything in a dark room in the Supreme Court. They weren't supposed to. It's not in the Constitution. So this is a huge return of power to people of the United States to make their decision, to decide what they think is right or wrong, and not have just a handful of people tell them what morality is. So it's not talked about that way, but it really should be. This is what the founders meant.
It really is incredible because I saw signs last night, power belongs to the people, and they were protesting. And I thought, no, that's what this document says. Now, can this go to, we know it can now go back to states, as it should be, and they can vote and do whatever they want. can this also just go right back to Congress and have a federal law?
They can. They can if they can pass it. Because again, the Constitution doesn't speak to it, and therefore it's up to the people. So they could pass a law, but they would have to do one of two things. They would have to, in the Senate, get 60 votes in order to what was called the filibuster. It's really it vote cloture. They could either get 60 votes, which they're not going to be able to do, or they could destroy the filibuster. And that would be a permanent damaging of the Senate. I mean, the last time they didn't have a filibuster was, before Thomas Edison, invented the light bulb. So, I mean, we're talking about that this would be, change the Senate forever, because the reason the Senate is considered probably the most well-known deliberative body in the world is because you can't just pass it with raw political power. You have to get some consensus from the other side. It takes that 60 votes, and it slows things down so that you don't have one party taking over and flipping the country one major direction to the other. The Senate kind of stops that and makes there be some consensus. If you destroy the filibuster, we're going to see court packing. We're going to see Puerto Rico becoming a state, D.C. becoming, we're not going to recognize our country. And I think I've mentioned this before with your audience even, Glenn, but if people don't understand how bad once you do court packing once, your country's over. And
right.
So this is the kind of stuff that would happen if they do get rid of the filibuster, as Bernie Sanders and others are advocating today, because they know they'll have to do that if they're going to push through a new law, a new Roe v. Wade by federal mandate.
And is court packing just one justice, or does it have to be several? I mean, I don't know who would go 5 to 5, but
it's 4. They've already filed the bill to add 4 justices to the Supreme Court. So it would add 4, which would then make the liberals have the majority, and they would just start doing whatever, basically like a super legislature. But the problem is, once you do it once, the court's over. It's just, a subsidiary of the majority party in power, and there is no rule of law anymore, and you don't have any rights anymore. You have whatever right the majority party wishes for you to keep, and that's why.
And you never really go back.
You don't. You look at people wonder what happened to Venezuela. That's what happened. Argentina. We can go through lots of countries. People don't understand, but when it happens that first time, you're done. You're tyranny, and really a dictatorship is where you go. So it's something that they tried in 1936, 37. FDR did, because he did not like the fact that they were not getting his New Deal through. But even his own party turned against him before it was over and said, "This is tyranny. We're not going to do this in this country," and it failed. But it's very dangerous, and it's something that they could only do if they destroyed the filibuster, which would be what they had to do to pass a new Roe v. Wade in federal statute.
So that is the thing that I'm looking at here. I'm not sure they release this to do anything but to pour fuel on the fire right now. Why wait until summer? Pour fuel on the fire right now to get court packing done and the end of a filibuster. I think it has more to do with that than the actual judgment from the court. Would you agree?
I think it's both. Probably they're hoping they can intimidate one of the justices. But this is the beginning of what I've been predicting for months. I think we were just together recently, and I said I think this is coming in June when these decisions start coming down. And I think they're going to go for court packing with a frenzy. I think this is going to be their new election approach, because they're obviously not working well under the current polling and et cetera. And I think this is going to be their attempt. And we're seeing just an early sort of release of that, in addition to a hope that they can intimidate one of the 5 justices that supposedly are on this opinion. It only says Alito, but again, part of the leak was that 4 other justices, not the chief, but 4 of the others are with him. So they might hope that they can pick off a Kavanaugh or a Barrett who lose their nerve. I don't think that will happen. I think this will entrench them even more because, it would just destroy everybody would know that they changed their principled opinion because of pressure. So I don't think that's going to happen. So I agree with you that I think long term this is their strategy and this is what they're going to do.
Kelly, can you hang on for just a second? I want to talk to you about the other cases that are coming up in June and the impact that they will have. We'll do that in 60 seconds. Kelly Shackelford is on the Board of Trustees of the United States Supreme Court Historical Society. He has earned his law degree from Baylor University, and he is also the president and CEO of First Liberty Institute. If you are thinking about donating money to any cause, I can highly recommend First Liberty Institute. They can use your money, and they are winning and actually leaving permanent marks. It's firstliberty.org. So, Kelly, you have been in front of the Supreme Court, and we were talking recently, and you said to me, we're probably more free. By the end of summer, we'll be more free, religiously speaking, than we have been in our lifetime. You also said, because of Roe versus Wade and the other opinions that you think are coming down the pike, that the left is going to lose their mind. What are the other cases?
Well, you've got Dobbs, which is the Roe v. Wade, which we're now seeing the precursors to. But in addition, and by the way, the way this works is the court issues all of its opinions by June, because the session will end and they will mostly leave the country and speak and teach and stuff at other places. So the opinions are out by the end of June. It's highly expected that you would have expected Dobbs, for instance, to be issued that last week, probably.
And hang on, let me ask you a question. Yeah. Why don't they just finish it now and make it official?
They might.
Okay.
They might. I mean, I don't know how far along they are, because what we saw was an early draft. But if I'm the chief, I think I might move it along now and say, we're going to get this out quickly, so all this nonsense will stop. Mm-hmm. But it normally would have been late. But in addition to Dobbs, you've got a Second Amendment case, which will be, I think, in favor of the Second Amendment and against the New York restrictions on guns.
Which would do what?
It would just bolster the Second Amendment and say that these types of restrictions are unconstitutional because there is a Second Amendment right to keep and bear arms, and this violates that fundamental right. Okay. I think you're going to get that kind of decision. I think we're going to. We argued a major school choice decision in December, and it's expected the way the argument went that we're going to win that case.
Which will mean what?
It will say that any time there's any school choice program anywhere in the country, you cannot exclude religious schools or religious choices from the parents. And that'll make clear that school choice has to be fair, and that everywhere it's going on, and there's a lot of programs out there, the exclusion of the religious schools is over. And so that will cause a lot of religious schools to come into being, because now there'll be resources that the parents have to choose what they think is best for their kids. So that'll be a big decision. The Coach Kennedy case, which we just argued a week ago Monday, that's a huge case, and it looks like it's going to be even bigger than expected, depending upon how they write the opinion. And again, this is a coach who was fired for going to a knee after the game to say a 20-second prayer thanking God for the privilege of coaching the young men he coached. And it's the first time the court has ever had a case on the free exercise of religious freedom rights of a teacher, a coach, anyone. So there's never been a decision on this. So it's going to affect a lot of people that way. But what people didn't expect is during the oral argument, the court got into a discussion about possibly ending the Lemon case, which has been around for 50 years. And if people wonder why our whole lives we've seen attacks on nativity scenes and menorahs and veterans memorials with religious symbols and, Ten Commandments monuments and all that, it's not because the founders said anything about that. It's because of this really bad case 50 years ago, and it's been the weapon of choice for secularists now for 50 years to try to wipe our society clean of religion. And it's pretty clear that maybe a majority of the justices are about to say that's over. And that's a sea change if that happens as well. So Those are just a handful, and there's some others too. There's a campaign finance. There's the border case that was just argued last week. So all this stuff is coming down in the end of June, and my guess is that the Marxist left is not going to like these things.
It is amazing to me as we are traveling down this road where the government seems to be going in entirely the wrong direction, and you're kind of losing hope that the Supreme Court now rides in and is doing remarkable things that, quite honestly, I would think would find favor in the eyes of God. Hopefully it buys us some time, Kelly.
Yeah, and it's what it's doing is these justices aren't themselves politicians. They don't go one way or the other.
Yeah.
But they're going back to the original meaning of the text of the Constitution, which takes us to our founding.
Kelly Shackelford, President and CEO of First Liberty Institute. You can find it and donate at firstliberty.org. I highly recommend that. That's the thing about constitutionalist judges. It doesn't always cut your way because it's all about freedom and rule of law.